Today we have Lauren Jones. She's an estate and business planning attorney. So thank you for coming today. We really are excited to have you.
Yes,
Yeah.
thank you.
Thanks for having me.
And off camera, we were just discussing a lot of things, estate planning,
way too many
LLCs,
things.
and all this other stuff. So we'll get into it. So thank you for coming today.
Yeah.
And go ahead, Jen.
To start with the basic, who would you recommend needs an estate plan? And what are some of the common mistakes you see people do when they are making an estate plan?
So I like to say anyone over 18 needs estate planning. It means a lot of different things, right? So sometimes people think that means a revocable living trust, which it can be, but estate planning is all the way down to powers of attorney and healthcare directives. Anyone over 18 needs it because no one is legally responsible for you anymore, unless you had a conservatorship, but that's what we're trying to avoid actually by doing estate planning. We don't want to have a conservatorship. The biggest mistakes that people make are trying to DIY this, think that they know the answers, think that they can just go online and figure it out, and they can, they can avoid talking to someone like me because they're like, well, I watched some podcasts or I went to some seminar and I got this, and they just don't know what they don't know, and you don't know how it all fits together. So that's a big one. And then in that, there's lots of different things. Like people think that all I need is a will, which may be, but not likely. It's kind of an ineffective estate planning tool. There's more to it than that people just don't understand. And then people like to add their children to their grant deeds while they're alive. That's a huge mistake I'm seeing all the time right now. And unwinding that is a mess. I've done it because they lose things when you do that. Things that you don't know about because you'll be deceased by the time that it happens, but they'll lose like stepped up basis. And all of a sudden there's a change in your property taxes now because it's not primary residence to primary residence. And I can't unwind that when we do that problem. So those are all these things that people kind of try to do. Again, it's all DIYing, right? The county doesn't give you legal advice when you record documents, nor should they. And so you got to just go down, fill out paperwork, and then think it's fine, and it's not.
What are the basic structure of an estate plan? If I were to come to your office and say, hey, put me together in a basic estate plan, what would you start?
I feel like there's a lot, like I'm going to give you the big things because that's the thing everyone's kind of looking at. So if I'm really looking at a full estate plan, I'm looking at a revocable living trust, a pour over will, a power of attorney, and a healthcare directive. Now, there's a whole lot of other little things that go along and not that get tedious and not really like what people understand, right? They're kind of things that people don't think about. So I'm not going to get into, there are other things. There are things to make kind of your estate plan very whole and really comprehensive that I add to my stuff. But those are like the big documents you're looking for. So when you don't need a revocable living trust, and maybe you don't have any assets to even need a will, then we're talking about a healthcare directive and a power of attorney. And then with both of those comes like a HIPAA authorization giving access to your medical records, or a living will if you don't want to be plugged into a machine in a vegetative state. So like in someone that's 18 that doesn't really have anything, what we're really talking about is a healthcare directive, power of attorney, HIPAA authorization, and living will.
What does HIPAA stand for?
Health Insurance Portability and Accountability Act.
Okay.
So it's about giving access to your medical records, right? That's the whole point of it. And so when it comes down to...
So a power of attorney wouldn't allow that to happen?
So it does. It does. Mine do say that in there. It does give access to medical records. I like to bolster that up with a HIPAA authorization so that we don't have any question that you are supposed to give these people your medical records so that they can help make your medical decisions. So sometimes they're conjoined, but I like to add that in to make sure we are abundantly clear this is what the plan is. And that living will says I don't want to be plugged into a machine, right? If I'm in a vegetative, irreversible terminal condition, I don't want to stay just plugged into a machine.
Why wouldn't that be in the trust document? Why is it in the will document? What's the difference?
It's not in a will document. It's in what's called a living will. It is a healthcare type of document. So it's not, we have a pour over will that if you have a trust, there's always a pour over will that intends to push your assets back into trust if they're not. So if we run into a situation where, a good example, you have a house and it's in trust and you refinance that house, and typically the mortgage lender is going to take it out of trust and push it back in, because when they want to deal with your mortgage, they want it in your name and they want to see titles that way, and then title will typically transfer it back into trust. But like we had a massive boom in refinances right in between 2020 and 2022. And some things weren't happening fast enough, and sometimes mistakes are being made. So if we find out later you die and we find out that your house got refinanced but not put back into trust, we would have an asset outside of trust. And so we would use your pour over will is to argue to a judge, well, they intended this to be part of the trust. They want this to be part of the trust. There was a mistake that happened. Can you please put it back into trust so I don't have to go through a full probate? That's a whole separate thing that goes with a trust.
Okay.
And that's why we call it pour over, because it's literally like pouring an asset back in.
And do they want to add, if you have, I know there's beneficiaries on life insurance or stocks, annuities, things like that. Do you want to add those into your trust as well?
So it just depends on the client's needs and how they're planning. So I would say most of the time, in one context or another, we are listing the trust as a beneficiary to a life insurance or policy or retirement account. At some point, we are doing that. Now, whether it is last or it is after a spouse, depends on how they're planning for everyone else. If we have young children, we want to talk about it a little differently than if we just have adult children. It just depends on how their plan is. So, but we will include them, and we will talk about changing beneficiary designations to fit with everything else.
In your practice, you talked about passing on like a home asset or an asset and doing it yourself, essentially.
Sure.
So I'm a father, I want to pass it down to my child, and I go down to the county and I record it that way. What's the problem that you see when things of that nature happen?
Okay, so right now there's like two problems. So we have Prop 19 that got passed in 2020 that changed the parent-child exclusion. So it used to be that you could pass property from parent to child and child to parent without having to reassessment your property taxes, which was amazing.
Right.
Prop 19 changed that quite significantly. Now the exclusion only applies if it's primary residence to primary residence, and it's only $1 million differential. So if the valuation to a current valuation to like what it is when the transfer happens is over $1 million difference, you're going to be assessed on what is up and over that $1 million. So what happens when someone does that today is most likely that child is not living with them. They're typically doing it to avoid talking to an attorney.
Correct.
They're like, I don't want to talk to an attorney. I've solved all my problems. I'm just going to put my kids on it. And then it's joint, because they understand what joint tenancy means. And they go, when I die, they get it. So except for the county is going to see that, say we got people added to the property, and therefore there's a reassessment. So that's problem number one. And if you're on a fixed income.
So let me stop you there.
Yeah.
If I'm the father and I put my child on the deed, it's still going to get reassessed, even though I'm still living in the primary home.
Well,
because the child is not their primary home. That's where the problems come in.
Okay.
So you change ownership, and it's not transferring as primary to primary.
Primary to primary.
Because the child's not living it. Now, if the child is living it, that's a different story. We can try to get that, but it's likely you're not going to. So that's where that gets a little messy.
Okay.
And if they're on a fixed income, and if they're, you're retired, you're not making more money, you're just living on what you're getting, and then all of a sudden your property taxes increase, that's not good. I mean, I just had someone die, and a San Jose property went from a $50,000 valuation to like a $1.1 million valuation, in that person's lifetime. That's crazy, right? That's a huge difference in some areas that will significantly affect how much you pay.
The property taxes.
Yeah, the property taxes. The next thing is stepped up basis. And this is a little confusing for people, but when you buy a property and you sell a property, it typically goes up in valuation, right? And there's capital gains and capital gains tax on that. So one of the benefits of giving a property to someone when you die is that we push the date of valuation to the date of death, and they only pay capital gains tax between the gains that got made between their date of death and the date of sale. So most people don't even realize, anyone that gave a property or added someone to their property didn't ever notice that, because they died when this happened, right? When they found out about it, the person had already been gone. So now the children find out, but we lose that benefit, that stepped up basis. When you add them while you're alive, you're losing the benefit of the stepped up basis, which could be a whole lot of money if, you went from, if you bought it for $50,000 or something, and then now it's, that's a huge difference. So you kind of basically, stepped up basis allows you to erase all the capital gains that happened during your lifetime.
Is the step up basis, is it automatically given to you if you pass away? It's given to you as a benefit to a child. If I pass away, correct? It's automatically done.
Well, I can't exactly say that because I'm not a tax attorney and I'm not a CPA. So I don't deal with it on that end of things. It's got to be reported, I believe, and they have to do something. But yeah, it's part of the law that you get the stepped up basis.
That's what I was getting at.
I don't have to, no one, as far as I understand, has to apply for it. And I think you have to report it to the IRS. But again, like I don't deal with that component of it.
No, one thing we're
Let
seeing,
those professionals do it.
one thing we're seeing when people pass away is the county reassesses the property immediately. So we're seeing all these tax bills coming through. Now that they've died, it's a change in ownership, is what the county of Sacramento is
Yes.
saying.
Yeah. It's getting a little complicated. They're definitely working faster than I feel like in the past few months. It feels like they're moving faster than I've ever seen them move before. We're sending, like when I send down the paperwork, I would send in the parent-child exclusion and the trust. I'm even running into some issues in certain counties because their assessor and their recorder are in different locations and they don't like sharing information with each other. I will send it all to the one place and then all of a sudden the other's like, I didn't get anything. And I'm like, what are you talking about?
Yeah.
I sent you all the paperwork and we're having to kind of move a little bit differently. They need to be notified of the death in order to reassess. Otherwise, so it's not an automatic thing unless they got notice, which that could be that someone went on the internet instead of doing probate or trust administration. The family went on the internet and said, oh, I have to tell the county, and then went down to the county. Well, then, yeah, there's going to be a reassessment because they don't know all the other paperwork that should be filed with it. I mean, I have houses all the time that we can't avoid the reassessment because no one's living in it. They're going to sell it. It is what it is. It also does depend on the time of year. If we're in reassessment time period with the county, like, you know, if they're already kind of in January, they're reassessing everyone's stuff. Like that might be a time where all of a sudden it moves a little faster.
So it isn't just for the wealthy. Everyone should have an estate plan.
Yeah. Everyone 18 up should have something.
Yeah.
And you gain, and everyone, oh, I get this a lot. Well, I have a mortgage on my house. Like I can't put it in trust. And that's completely untrue. I put houses in trust that are on a mortgage every single day. We just transfer them. It's not, the mortgage company cannot call a note on a house that moves into trust. You also want to always tell your homeowner's insurance policy that you got a trust because we need, especially in California right now, we need no excuses for someone to not insure your property. With all the fires that happened in LA, was it last January or something, February time? And like, we need no excuses. We have places in California that can't even get insured. So you always want, I always tell my clients, tell your homeowner's insurance policy that you have a trust now. They can do like an endorsement. They can do a secondary insured, whatever they need to do. That's their business. Again, I'm not an insurance agent. That's their business, but they will do something to make sure the trust is known.
No, they won't cancel you for putting it in a trust,
No.
correct? Okay.
Not as far as I know. I mean, who knows? Insurance companies do crazy things. Yeah, I mean, I'm surprised people are getting canceled just for where they live right now, but I mean, I can't control that.
So we had this going back and forth, and we talked about, and you corrected us on this. It's executed in self-interest. Can you further elaborate on that?
Yeah.
Maybe an experience that you've had with that.
Well, so I haven't had an experience per se, but I'm going to throw out your experience that you gave me earlier. So you were saying that it sounds like what happened is that before someone passed away, there was a power of attorney to which both children had authority to act on behalf of a parent. And then at that time, and in that power of attorney, I mean, my power of attorney has similar things. It allows them to be able to transfer property and do certain things. They transfer the property to themselves. I assume the reason why it was done is because they wanted to avoid probate, and at that point, mom was, or the parent was incapacitated and could not execute a deed. That happens a lot, right? Where someone is at the point that we have power of attorney, we waited too late to do all the other documents, so we can't get the property transferred. And I think the example you guys gave me was that title wouldn't insure.
Oh, yes.
Yes.
It was a brother and a sister.
Yeah.
The mom was incapacitated. They transferred, using the power of attorney, the deed to themselves, each half interest, no other beneficiaries. And yes, title would not insure. They want to do a quiet title action.
I get the title company is there to protect people, right? And sometimes things happen and people are transferring properties and they're concerned. They want to make sure that there is safe, good title to be able to transfer to somebody else. I fully understand that. But in the context that mom gave them power of attorney at some point while she had capacity, to me means she obviously trusts them to handle her things. Second of all, we have the situation that they were the only two kids. Now, if they were ousting other children, I would say good on title. That's really important. Like, go figure that out. But they were the only two people. So in my mind, if we went through probate, we would have got to the same people. It would go to her two kids. There's no one else for it to go to. So in either context, I don't know why we needed to go through an entire legal action to do the exact same thing that would happen under the law if they had done this before she died or not. The only thing, and you can't do anything in probate now because it's already been transferred to her, so probate's not going to touch it. because it's not a probatable asset. So I think title is being overly cautious and not understanding how something would actually work. Now, there might be more facts, right? This is my, my little like disclaimer. There might be more facts in there that I don't know that cause title to do that. But I would say that I would have had conversations with title first to be like, okay, what's going on here? Why are we doing this when it would have gone to the same people if there aren't any extenuating factors involved?
Right. And it had been done like over 50 years ago, and both children had been deceased. One part of that had already been probated for one of the deceased children. So, but there was no
More levels of complexity, right?
Yes.
Already more levels of complexity. So they couldn't even talk to the deceased children because they're now gone. And now we have 50% being probated for each of them.
correct.
But I mean, if probate was going to like once it transferred and probate wasn't going to have an issue, they wouldn't have even questioned it.
No, well, a title company was still not willing to do it, even with probate.
I would also say go find a new title company. I literally have told people if your title company is being highly difficult and they just don't want to take the risk, go talk to another title company.
So if I'm in the state of California and I die with just a will, what is the problem with that?
You're going to go through probate. And you
Wait.
don't want to do that. Well, you're not going to care. You're not going to be here. But it's.
I mean, we get this all the time. I have a will. It, basically lays out. It lays out exactly what I want to do. Here's all this A, B, C, and D. This is where I want it to go.
Uh-huh.
And then both her and I go, well, hey, you're just going to end up in probate. Why is that? Is there a law? I mean,
Time and money.
Time and money.
We're going to simplify it. Time and money. So it's going to take your family at the very, very least a year in order to get any of the money. Doesn't mean we can't sell the assets ahead of time, but it's going to take a year for them to get the money. It's just,
Let me go back. I mean,
yeah.
just because you have a will, you're still going to go through probate.
Yes, a will is required to go through probate.
Okay. In the state of California.
Yes.
Okay.
I don't talk about any other state. I don't practice in those. I only practice here. It doesn't matter what part of the state, but only in California.
I think most people feel what I was trying to get at is that if I have a will, I'm good, right? Everything's going to be taken care of. I die, all my assets are going to go to where I wanted them to go.
It is. That part is good. Like you're going to go to who you want. Sure, if that's the basic level, that's all you care about is it goes to who I want.
You're taking that will and you're taking it probate and it's going to be validated by the judge, correct?
Yes.
Okay.
Yep.
And
Yeah.
who can contest that? So even if you have the will and somebody says, well, I was told this and they never updated and they're leaving me out and I'm entitled.
So anyone that has like any heir, so that would be your kids, or if you didn't have kids, siblings, and I mean, like that's the lineage family, your kind of your bloodline family can potentially contest. Now it depends on if there's a no contest clause in the will. So there typically is, unless someone tried to DIY this, and then there probably is not.
Yeah.
There is something called a holographic will that they have to handwrite, date, and sign. They're not going to have a no contest clause in that. So a no contest clause would say, we do them in trusts and wills all the time. It says if you contest anything that's in that, you're not going to get anything. But there's exceptions. So like if they really felt that you were unduly influenced, if they thought that if you gave everything to your caregiver who, has only known you for a year and ousted your whole family, well, then we might have some questions, right? If you gave it to some new girlfriend that was swinging by, okay, maybe we have some questions. So we can't let someone be abused, right? So it's not a free for all that just because you got nothing, it can't have like someone come in and unduly influence someone to change their will and then expect that they have full immunity and protection. That doesn't work. So it's going to be, there are some exceptions to that no contest clause, but essentially it doesn't stop, even if you have a no contest clause, it still doesn't stop someone from coming in and saying something. It is a deterrent, but if you really think that something's wrong here, they're going to come in and do it. Now, there's a time frame to contest. It's not forever. This is why going through a probate, there's a process. I mean, even with a trust, if I have to give notice, I give 120 days for them to contest. If there's any issues, we have to give notice to the beneficiaries who may be the same as the heirs and may not be. Because if you're giving money to your friend, that's a beneficiary, but your heirs are your kids, right? So we give notice to everyone in their time frame to object.
I thought you couldn't object with the trust.
You can still, if you still think there's undue influence, if you think someone did something, a parent comes to me with their child in the room and they have 4 other kids and the parent says, I want to give everything to this one child sitting here. That child is immediately leaving the room. You need to leave. We need to have a conversation. Why are you doing this? Because I cannot have you sitting in a room with me because there could be undue influence there. Like, what does that look like? What is really happening? Is it really that you have no relationship with your other children? Or is it really that like this person has just now brought you in to make changes to their documents? So it's the same concept though in a will or a trust. That no contest clause applies just the same.
Okay.
I'm going to throw kind of a random one in here.
Yeah.
We have some clients that called us for help. They were the lien holders or the mortgage holder of a home.
Okay.
The person passed away.
Uh-huh.
And the mom filed for probate. They technically thought that they kind of owned the home. It went back to them because it was a seller financing kind of thing.
Uh-huh.
But the probate has been dragging out and they cannot get her to sign a deed in lieu of. What is their recourse? Like, how do they go about doing that? If there was no will, no trust, it's all going through probate.
Do they have a contract for
They have a contract.
Did
and
they
have
file a creditor's claim?
Yes, and it got denied.
Why?
I am not sure. That's kind of what we're trying to figure out. But the court keeps kind of dragging it out. They tried.
Oh, it got denied by the executor. The executor just tried to deny it.
Right. And she doesn't even have full authority. She has limited authority. And they tried to get the property on the market. The property does not have value. So now what they're owed as the lien holder outweighs the value of the property. And they
Is
wanna
there any
drag it out
money
another
in the
year.
estate to
Not-
even? Well, then why are they fighting?
That's what we can't figure out, and why the court
Well,
is allowing
what's the
them.
debtor going to get? The debtors, if there's no money,
They
if
want the house back.
they want the house back. Okay, there's enough to at least give them some money in the house.
Well, yes, they would be foregoing all the missed payments and interest because
Sure.
there's nothing for them to get. But it's kind of like a foreclosure. If they get the property back, then they can either rent it and hold on to it until the market comes back up, or
They're going to have to pursue their creditor's claim with the court. They're going to have to push just because it got denied by, like, that wasn't a judge that denied that. That was just the executor that probably denied that because the executor doesn't want to pay it. So then they have recourse in that action. I haven't had that happen before. Most of the time we're trying to pay. I mean, because I wouldn't tell my client if there was an actual true debt, I wouldn't tell my client as the executor to deny it because we have to pay off the debts. So if she's not being, I don't know if that executor is being represented or not.
nope, all pro per.
Yeah, that's what I kind of assumed. Their recourse is to pursue the creditor's claim. So they need to like go through that process. And I don't really deal with it on that side. Like I don't represent creditors to know how that works exactly and how they pursue it, but they're going to have to like continue through that process. And I'm sure that the paperwork has their like recourse actions on it.
Yes, it does. And they
Yeah.
tried to pursue that with
They should hire an attorney that's willing to help them do that. So are they trying to do it on their own too?
yes.
Yeah, that's not going to work out. You guys are just
That's why I
a bunch
told
of
them-
people DIYing this all together that are like going to argue in the court. I mean, sure, go to court, tell the judge, but if there's a contract that was signed and is, a legitimate contract, I'm not sure exactly what grounds the executor has to deny it, except for they just don't want to pay it.
And I keep telling him, get an attorney, do it, because you're just throwing good money after bad. If you,
Yeah.
you keep just putting it in there, and there's no value to the property at this point. So
Right. Yes, they're going to spend a whole bunch of money to go after it. How much is like even owed?
I think it's like $415,000 at this point, and the home is maybe worth $360,000.
Are they even able to like sell that home to recoup that money? Like,
They've
are they?
tried? They've had the executor has had it on the market for I think 8 months with nothing.
I mean, that's a lot of money for for the creditor to get back. But if they're going to get a property that they can't sell, like what are they going to do with that? I don't know the details I have the answer for, but like those are the questions I'd be asking myself. Like, is this the route I really want to take to get a property that can't be sold that I'm just going to sit with and it's going to rot, I guess? Like at that point, is it worth the money? But I mean, I would suggest they talk to an attorney to see if it's worth the money to pursue the creditor's claim.
Perfect. I'm going to give them the number.
No, I don't represent creditors, not me, but another attorney can help with that. But yeah.
Awesome.
How do they protect you from creditors and beneficiaries and also from the public?
So a trust only protects the beneficiary from creditors, not you as the grantor. So the grantor is the one that owns the money.
Right.
They're the ones that put the money in the trust. They don't get protection from creditors because it's your money. Like you don't get to hide it away.
So but when I pass away with a trust and I'm on Medi-Cal, for example, or I owe a bunch
Sure.
of money on credit cards, for example, or I've got
Your debts
my
are still your
mortgage.
debts.
Yeah, my
Yeah.
debts are still my debts. How does a trust protect my beneficiaries from the estate just being essentially brought to zero because I owe so much money?
So it doesn't. So Medi-Cal pullback, yes. If you put it in trust, you don't have to deal with the Medi-Cal pullback or Medicare pullback, right? So that's a benefit. So whatever you got on that, they're not going to come back from because it's in trust. However, your credit card debts and all that stuff, those are fair game. And also they're not money that your children are required to pay back individually, right? Your children are not responsible for your debts. Now your spouse, because we're a community property state, your spouse is responsible for your debts. So even though you went and opened a whole bunch of stuff in your name, your spouse is going to have to deal with that when you die. The way that we deal with it is that we negotiate them down. So you hire an attorney. So this is what happens a lot. Someone dies and people immediately like, well, there's debts, and they start paying the debts. And I'm like, don't touch them yet, because we can have some conversations and potentially negotiate them down to get more money for the family, depending on how much money is left in the estate, right?
That's great advice, because we get that all the time. Like, hey, should I pay these debts down? Talk to an attorney.
Talk to an attorney first, because if I can get 40% knocked off of that, that's amazing, right?
What about an irrevocable trust? Like,
well,
if you
that's a
have
whole
one for
different
someone
ballgame.
who's living and you're in charge of all that, are you still required to pay their debts?
So an irrevocable trust isn't your money anymore. It's sequestering it completely away. So it's not meant for you. It's meant for the beneficiaries. And therefore, it is not responsible for your debts, because it is not your money. Let's talk about revocable trusts. I don't really dabble in irrevocable trusts that often, fully understand what they do. But I mean, most of the clients, that is not what their need is. I know, like, we had mentioned kind of talking on a few minutes ago, we kind of mentioned this idea of someone was trying to qualify for Medi-Cal or things like that. Yes, those are options that happen. Most of the time, elder law attorneys are dealing with those. Not so much. It's not really my practice area so much. The thing that I want to mention is that children, your beneficiaries, not just children, but your beneficiaries can avail themselves from creditors depending on how you give them their money in their trust. So if they are not the ones that are getting the money, if the trustee is holding that money and it is managing that money and giving to them over periods of time or ages or whatever it is that you set up, their creditors don't get to come take their money. So while people think that your trust can do that for yourself, it cannot do it for you, because it's your money. You know, we have to deal with debts. Like I mentioned before, we got to talk about negotiating debts. That's super important. Don't just pay the debts. It's always a cost benefit analysis. If the time that it takes me to call to negotiate down the debt is going to be more than the debt, when obviously we're not going to do that. But if I can knock a few $1,000s off your bill so that the estate doesn't have to pay it, then that's awesome. If there is no money left in the estate, then we have to tell them that you're insolvent. And that means the debts go away. Those are all the different options for the grantor's benefit, right? When they're gone. But the children that get the money, we can actually protect them from their creditors and their divorces and their IRS debts or anything else if we plan in a way that does that. Now, that depends on every client. Most of my clients are not needing that for their kids, but it just depends. One thing also, though, to attach to that is this common misconception that my inheritance, like if you give inheritance to your child, it's community property for them because we live in a community property state, and that is not true. So inheritance is always separate property until it is what we call transmuted into community property. So if I got inheritance from my parents and I kept that separate, I could create my own separate property trust if I wanted. I could have that go only to my daughter when I die. I could do all of those things and I can keep it that way. As soon as I start taking that money and putting it to my community property household to buy a new house, to upgrade my house, to go on family vacations, to pay off our debts, I've transmuted its character. So if I got divorced later, trying to argue that that's my separate property is unwinding a whole lot of a mess that is very difficult to do, depending on how long it's been.
Probably the judge will look at your intention, right?
No, it's commingled.
Well, it's commingled. So they'll look at the
Commingled now.
intentional and trying to go back. Like if it was 20 years ago, trying to go back 20 years is a hot mess. Like,
Yeah.
and that's a family law world, right? But inheritance is always separate property. So when we are potentially protecting a child from their divorces, it is because we are concerned that that child might commingle those assets, and we don't want them to have the pressure to do it, or we want to kind of hold it away a little bit, where they might get they might get money, but they're not getting all of the money. So there's so many different types of way to plan that.
Now, let me just ask you a real quick question, since we're talking about debts and we kind of touched on the tax part of it. If the taxes that come out, if an estate has already been dissolved, it's gone through probate, everything's been dispersed, and then all of a sudden you get a tax bill or an unsecured tax bill, how does that work? Is the administrator now responsible for that?
You shouldn't have that happen.
I've had that happen. So
That
that's
means
why-
that someone potentially did not figure out all that, because you shouldn't close out to the estate until the final tax bill is paid. I've not had that happen because they're coming to me and I'm like, we would have a conversation with the CPA. We would know if there's any tax bills left. Like we would kind of have money planned to set aside before we gave out the money. We always have a holdback. So that depends upon how much we estimate the taxes to be, right? So if we expect there to be a $20,000 tax bill, we're going to hold back probably $30,000, and we can give money away. We can give away everything else, but the $30,000 until we deal with the final taxes. When you ran into that, did they have an attorney that represented them in that process?
Yes.
Okay. So I'm not sure why that would have happened, but it's typical that we don't let that happen. It was a trust, not probate.
It was a probate.
See, that's all. You'll see that's not a good thing either, because you're supposed to actually declare in the probate that you've dealt with all the taxes. So there's something didn't go right there. And I don't know what that would have been, but we actually have to write that, like, there's the federal taxes have been taken care of, or except for like a final tax, whatever. But like, again, in a probate, we still have holdback. Now it depends on what it is, but we would still hold back money. What was the tax for?
It was
Now
an
I'm so curious.
It was an unsecured property tax bill and then change of ownership bills from when the person passed away up until the point of sale of the property. And then we were getting them again after the fact. So, and then this has happened to multiple clients. Administrator is getting the bills, and then the new homeowner is getting bills from the tax. It's just a very
Did you
weird-
clarify it with the county and the assessor? Because like that doesn't seem.
Yes, I've
Well,
actually gone
because
down a couple different times to ask them on different ones, like why are these dates? So we have to go back to the dates, and so some have been paid, but then they're sending unsecured tax bills.
Well, it sounds like the one that's going to the executor would be the one for the time period between the date of death and the date of sale, which I'm not sure why that would have taken so long.
Yeah.
So that's an issue. And then, but I mean, honestly though, so this is like part of why probates take a long time, because you sell and you don't distribute right away. You got to go back to the court and get final distribution paperwork. So like by then you should have gotten, because you would have sold. That means that they know about the new owners. They're going to give a tax bill to the new owners. They would have given the tax bill to the old owners. So like, I don't know if things moved faster than they moved too fast. And that's why that happened. Or I can't really analyze it exactly,
No,
but
that's
it
what-
sounds, you kind of have to deal with that in that process. You should be dealing with that in that process. So
Right. Some
Shouldn't
taxes
be a
were paid. And
surprise.
then again, there was tax bills after everything had already been distributed
I
through
would
the
call it
court,
county.
closed out, and all these other tax bills come, and we're like, wait a second, this doesn't
I
seem
mean,
right.
if that's the case, it was supposed to be part of the estate. And depending on how many beneficiaries there are, I would probably go back to all the beneficiaries and say, this happened. You all owe a portion to cover this. And I'd go that direction. And if it was just the one person, it's going to come. So it's like, it's going to come out of their pocket. But in reality, it is estate money that was given to them. So like, that's kind of how I would go about it. If we really ran into this, like something just did not go the right way, and there's a tax bill and the assessor says it has to get paid and there's no mistakes here, I would make sure the executor goes back to all the beneficiaries and say, this is the portion you owe. And ultimately, if they won't pay it, then someone's got to pay it, because otherwise we don't need the taxes assessor after us.
Yeah, that's what I was curious about. How did
Yeah.
that work?
It's messy.
So DIY, doing it yourself. Let's just circle back and kind of clarify. Do it DIY. If I'm doing it pro per, basically on my own,
Mm-hmm.
and I wouldn't know about the creditors, and and asking creditors if I can slash my, the estate's liability. Basically, you're saying an attorney will know this. So ask the attorney, what can I actually limit or what can I reduce in terms of creditors, right?
Well, I would say it's worth it to hire an attorney to just help you do this with you, to do this for you. Like, you don't have to call the creditors, the attorney's going to do it. But like, we get paid percentage based upon, so earlier we said, was it time and money is why you want to avoid probate. We get paid a percentage based on the gross value of assets. $400,000 in assets is $11,000 to the attorney, $11,000 to the administrator, and about another $2,000 in court filing fees and costs. And that's a small estate in California because houses are worth a lot of money. So I would say it's worth it to hire an attorney to help cut some of your debts, to do those things, to make sure to go through the process, because that time component, when you decide to do it yourself and act improper, the amount of time it's going to take you is going to exponentially increase. Because I was in a court hearing once, I was online, it was in Auburn, and I watched the judge say to a woman, okay, well, it's so nice to see you again. He had seen her 5 times and they still didn't even have letters in order to be in charge because she missed a box. She missed this. They're not there to fill out the paperwork for you. They're not attorneys. But he was being super nice and sweet and helpful, but I couldn't imagine having to do that and take 30 days to get on the calendar every time. And that's if you immediately file again and having to go through that process when you could just have done it once and the attorney would have taken it for you. It doesn't mean that we don't run into issues. I'm in a new county. They want something different, but we know how to fix it.
Navigate it.
We know how to check the probate notes. We know how to fix it. We know how to get it done. So yeah, no one's perfect, but just spend the money on hiring an attorney to do it with you.
Yeah, we get a lot of pro-pers that exactly what you just said. They didn't check a box, or they left someone out, or now they're back at square one, and the probate notes say you got to do X, Y, Z, and then they don't, and then the judge gets a little upset.
Yeah, and every county, how the judge is going to react to you, it depends on the county. Sacramento County, it turns a whole lot of cases. We just got a new probate calendar in the past couple of years, which was amazing because it would take us about 5 to 6 months to get on calendar from a filing. So that whole year timeline was like 3 years. There's just no way you can get it done. If every time I have to file to be on court and I have at least 2 court hearings, at least, it's going to take me 6 months to get on the calendar. It was a lot.
We do a lot of different ones in San Joaquin County, mostly in Sacramento County. And we've noticed the difference, when there's not as many judges or there's just not enough staff, it could take a really long time for just to get your letters stamped, whatever it takes. So it really just depends on the county and the staffing in our experience.
Yep, it does.
So switching gears. Sorry.
Go ahead.
For the business planning part of it. So if you want to start a business, an LLC, and add that into your estate plan, would you combine that with your personal estate planning, or would you keep everything separate?
So it is attached. It has to be attached. It's an asset. So a business is an asset. It has membership interest. Really, it's your membership interest. If it's an LLC or if it's a corporation, it's your shares, right? Those have to be incorporated to your personal trust because they are owned by you. So we have to we do definitely work on it on both sides. So we have that your shares will actually be owned by the trust, and then we will have it referenced in your LLC or your corporation as well. So we do I work with a lot of people that we have a business or we open a business later and we're doing their estate planning, or I start with the business and I do estate planning later. So we definitely have to incorporate them. They are separate entities. They're separate things that I don't necessarily call a trust.
Do you have 2 different trusts, or is it just one?
One.
Okay.
Because they're owned by you. They're not owned by, it is it's an entity. Your bank accounts are in the name of the business, all of those things. The ownership interest in a business is shares or membership interest. And those are owned by you. So you have to get those to your trust so that it goes through when you die, it's an asset. And if it's over the probate threshold, we don't want it to go through probate. We want it to flow through your trust and go to who you want it to. So it's got to attach to your trust to make that possible. But the entity is its own separate beast. It's its own thing. It's referenced.
Within the trust?
Yeah.
Okay.
Can you create a separate trust for that?
For a business?
So say you have business partners and my spouse has nothing to do with my business. So I want my business partner or partners to have the shares or everything it's in that business that's half theirs, or half mine go to them. Does that make sense?
It does, but there's multiple different conversations having that. So my first thought is, control in the business and ownership of the shares are 2 different things. So you may want your business owners to have control, and that can be part of how you build your operating agreement or your bylaws that says, if I have a new shareholder, they do not have a voting interest. So it's got to be dealt with on that side. The ownership side, my question is do you really, you could gift the shares to your business partners, but also my question is that what you really wanted to do, right? If you have a business that's worth $1 million and 50% of that belongs to your spouse, do you not want that to go to your spouse? It depends on the value of the business. So you got to be really careful on how you do that. It could be that you do give it and you could have it in your trust. They could be a specific beneficiary that says, this goes to William Rod Hooks as my beneficiary. He gets the other half of the business. My question to the client would be do we understand what we're doing when we do that? Do we really understand that you are giving away an interest in this business that maybe was intended to actually go to the spouse? So it's not, I definitely wouldn't jump to that first. And most of my clients, we don't jump to that. It's going to the spouse. Some businesses we have to get a little creative because we have specific licensing requirements. That business might end with that person. If it's a sole proprietorship, it will end when that person dies. So then it's just a matter of the bank accounts. So that we reference them in the trust to make sure that those bank accounts can get moved over if we had to, because it's a sole proprietorship. It's not an entity, but still, it gets complicated sometimes.
So being incapacitated, I'm a business owner and I own 50% of it with a partner, and I become incapacitated.
Yeah.
How does that work out in terms of like, would my spouse take over 50% of my portion of the business? And would that even be the right thing to do to my partner that, is trying to run the business and she knows, or he knows exactly what's going on and my wife doesn't? You see where I'm getting at?
I know what you're saying. It just depends. So it depends on how you guys built the operating agreement or the bylaws. It depends on the likelihood is that your spouse doesn't necessarily come in and gets to have control. And so officers or members are different than sometimes the interest, because you could have managing members potentially. It depends on what we're talking about. In an LLC, your members, even if they're managing members, are going to be owners because they're going to have a membership interest. In a corporation, we're going to have officers who may not even own the company at all. So we can have officers, we can have shareholders. They can be the same, they cannot be the same. So running the business in a corporation depends on who your officers are.
Okay.
And that just depends. And so the likelihood is you're incapacitated, the other officers are stepping in. And your spouse might even have a voting of the shareholders, but they're not running the company every day. So it really depends on how the business is built and what happens and how you planned in the business side and you planned in the estate planning side. But like the one thing you have to understand is that ownership and management are not always the same thing.
Two different things.
They can be the same, but they're not always. I tell my corporation clients all the time, you have to wear two different hats. You have a shareholder hat, and then you got to take that off and you have to have an officer hat. Because a lot of times you're seeing a business, family owned, even with maybe a couple partners, we're the shareholders and we're the CEO, CFO, secretary, we're all of it, right? That's most of the time what we're seeing. The bigger the business is, the less likely you see that. But so you have to really make the understanding that you're wearing two different hats. And then on one portion, you're like, oh, okay, well, today I'm voting as a shareholder. The shareholders have to decide who the officers are. The officers then decide which roles they have, but they're different, right? So you have board of directors meetings for your officers, and then you have shareholders meetings for your shareholders. So it's multifaceted. So it just really does depend on how you set it up and what happens. But most of the time, just because the one is incapacitated doesn't mean that the spouse is jumping in on the decisions. But my thing is, like, if you're an LLC and you're only by yourself, or you really need to make sure that you have someone that becomes a little more complex. Like, who do we have put in charge at that point? Honestly, things probably have to pause a minute. But if you're only by yourself, then we have who's going to sign the checks. No one really has authority at that point. So that gets a little more complicated.
Before we started the podcast, we talked about protection, and we get a lot of LLCs that buy property, right? Specifically.
Okay. Yeah.
I'm just a regular old LLC and I get sued. I own an LLC and I have a rental property in there, and I'm a property, I own this property and I'm renting it. Now they want to sue me because, they hurt themselves and they failed. Now they want to sue me. Mm-hmm. What protection or not protection does the LLC give me as the owner of the property?
Well, you have the corporate veil. So it's this invisible shield between you and the LLC. So your personal assets, that's why you create an LLC or a corporation, right? You want to separate your personal assets from your business assets. Now, that corporate veil can be breached. It depends on
This is what I'm getting at. Like,
yeah, can you do that? Yes, you can. So it's not automatic, right? Just because you went to the Secretary of State and you opened an LLC does not mean that you are automatically protected from anyone suing you personally. That's a common misconception.
Right.
You got to keep the business separate and apart from yourself. One of the biggest, easiest things to find, commingling assets. And I used to do business litigation, so I know how to find these things.
Explain what commingling means and like a basic commingling mistake people make.
You are paying for your business expenses out of your personal account or vice versa. Did you go on a vacation to Hawaii and you're a trucking business in California? Why did you go to a vacation in Hawaii? That is a commingling of assets because that is not a business expense. Tell me why you were there for business. I had a conversation with a forensic accountant once, big forensic accounting firm. And, there's this common conception that people say, oh, well, you're going to take your board meeting, go take it to Hawaii. And that's a write-off.
You see that on
You
commercials
see it
all
the time.
Right.
And his answer was, you only can write off the time that you spent on that board meeting. You don't get to write off the rest of your vacation. He's like, that is something easily found. Now, that was like a shock to hear because we hear this all the time, right? And this is someone that investigates people's finances for this purpose. And that's what he does. And he's like, nope, we don't get to write the whole thing off. You get to write off the time you spent there. Now, if the whole trip was work, great. If the whole trip was not work, then you 50-50 or whatever it is. Obviously that could be difficult to prove at some point, but I mean, I have been in cases pulling financial records is easy in a litigation. And I have pulled financial records and I have sat in a deposition and asked people questions saying, I'm sorry, you went here and where and bought what on what, like, what are you are this type of business. What are you doing? This doesn't even match. Oh, well, we just thought that it could be a business expense. It is not a business expense. So now you've commingled assets. Also, the other big one that people do all the time, personal guarantees. So you think that you're like, well, I have an LLC, I have a corporation, and and that means they can't come after me personally, but then you personally guarantee everything. Well, then of course they can come after you personally because you just agreed that they could. So you might have created the separate entity, but then when you sign the contract with the lease, with the car, with the property, you gave a personal guarantee that and of course, anyone that you're going to buy, sell something, like anyone that's on the other side of this wants you to sign a personal guarantee, right? Because they want to be able to come after your personal assets. So you sit there and you sign a document saying that if I default on my loan, you can come after me personally. Well, then it doesn't matter if you had a corporate veil and you're perfect in your business. You gave them permission.
So I bought a car in my LLC. That's a perfect example.
And then you signed a personal guarantee that said, if I don't pay off this car, you can come after me personally.
Right.
Okay. Well, you agreed to that.
Yeah.
Like, what am I supposed to do about that? You agreed that was okay.
Right.
Because they said to you, you need to sign this, and you didn't argue with them. And they said, well, or they said, we won't sell you the car if you don't sign the personal guarantee.
So is that like them asking for your personal information, like your social security number? So like we have an EIN for an LLC. Would you use that to purchase the car in the name of the LLC
No, it's probably purchased under the LLC. It's a separate contract that says that if the LLC defaults on making the payments, it is almost like a co-signer. Like if you really want to break it down, it's like you personally co-signed and said, if the LLC defaults, I will pay it myself.
And
So
that
that's
screws you up.
Well, how are you going to go back?
Don't realize that when they're probably in the midst of signing all the paperwork and doing all the everything that you do. So that's something that you need to be aware of when you go to do something on behalf of the LLC.
Yeah, I've had to dissolve businesses, right? Someone died, right? Trying to dissolve their business. And I mean, I've also dissolved business when people haven't died, but in this case, all these debts. And we're looking at the debts and we're trying to figure it out. And we have debts that they personally guaranteed stuff, they commingled assets. So we don't get to make this really hard claim that says we are not paying anything. You have to come after me personally. You have to lawsuit because they commingled everything. So when they commingle it all and have those personal guarantees, I'm forced to negotiate it all down, get to a place that they can pay off what they can pay off and close it out to dissolve it because we have no arguments anymore. We have nothing to say. You want to be able to say, I didn't commingle funds. I didn't create this as like a shell corporation. Like, don't do that. Like, please don't. Like, opened it essentially to like as a way to funnel money to yourself. That's a shell. Don't do that. That's not helpful. They don't have corporate compliance. They're not doing their annual meetings or minutes, depending on the type of entity you have. They don't have bylaws or operating agreements. These are all things that cause you to have problems. Now, I'm not saying that there's like one thing that's going to like completely kick. Like if you accidentally one time bought
groceries
on your business card, no, the world is not going to fall apart. But most of the time, no one's doing it accidentally one time. It's a practice.
Mm-hmm.
That because they went from a sole proprietorship that it didn't matter. And then they decided to open an entity and they don't change their actual way they operate their business anymore. It happens every single day. And they're like, well, what do you mean? This is how I've been doing it. And I'm like, okay, well, why is the court going to treat you as two separate entities if you don't treat yourself as two separate entities? that is a really hard argument to make. And then we get to argue that we get to breach the corporate veil and go after your personal assets. So then you did all this thinking you were protecting yourself, and you didn't. I would say that, like, no matter which way you look at it, if you have a sole proprietorship, or because sometimes we don't have to have an entity. I think everyone jumps to this idea that, like, oh, I should open an LLC or a corporation. And I don't always agree. It depends on the circumstances. If you don't have a high risk business and you're not making a lot of money, why am I going to open an LLC that you have a minimum $800 tax every year, and you have corporate compliance, and you should hire an attorney because so you could do it right? Like, it's not cost effective
It's the
for you.
self-employment tax that usually people try to get rid of or minimize, right? So with an S corp and all that.
Well, you can be an S corp election if you're an LLC. That's another misconception, right? People tell me I have an S corp. That's not an entity. That's a tax election. So, and that's up to your CP if you want to do that or not. But like, you have an LLC or you have a corporation, and you can, either one can elect to be an S corp. Okay. So it's just how they're taxed, right? You might do that for those purposes. That could be a good reason. Sometimes people, honestly, they're doing it for the liability because they just think, and that's my job. My job is to talk about the liability.
That's what I would think as a normal person. Like, oh, I got an S corp, I've got an LLC, I'm protected. And you're just saying that could be punched right through if I'm commingling.
If you're commingling, if you're not doing things right, if you've, it can be. I mean, that's the arguments to be made. So it's more complex, right? It's, it's a weighing the factors, but it's not an automatic, I can do whatever I want because I have an LLC, so therefore we're fine. Like, it just doesn't work like that.
And we talked a little bit about anonymity and
sure,
trying to keep that, because a lot of people also want to keep that anonymity so they don't get sued or personally sued.
Well,
is that impossible?
Well, I mean, I feel like in a lawsuit, we're all going to find out who it is. So like, because we're going to do discovery and we're going to find out, and you'd have to argue really hard that you should not say who the owners are. So the idea that I'm going to create anonymity so I don't get sued, I don't know how feasible that actually is. The anonymity that, like, we talked about, kind of like, let's say you're creating an entity in another state that then owns the entity you created here instead of a foreign registration. So like, I could create a Delaware corporation and register in California as a foreign entity and still be here, but that's not really, it's almost like we're creating an entity in California that is owned by, say, the Delaware corporation or something like that. So you can create extra levels, but like, ultimately at some point, if we were in a full-on litigation, we're going to just try to discover all of it. And honestly, I personally don't believe anyone is completely anonymous. You put in information places that you forget exist. Other things get caught places. I've had people, I was telling you guys earlier, I've had people that tried to talk to me about certain things, and they were talking to me from some fake Facebook account or something. And I was cautious, like, I'm not talking to a bot. So I started doing some research. I figured out who owned their business. I figured out who they were. And then he was shocked when I got on the phone and I said, so your name is this and da-da-da-da-da-da-da. And he goes, I can't believe you figured all that out. I mean, it took me 10 minutes to figure it out. It wasn't as anonymous as he tried to make himself by not listing to ownership anywhere and doing all these things. I still figured it out. So, and I'm not saying I'm not even that good at it. Like, some people are way better. There's private investigators. They're way good at this stuff. But there's some level that someone's going to find out. And now we're getting more and more difficult, right? So we have all the stuff that happened with businesses having to report ownership, the Board of Equalization that was happening, that like now has made it so that this was happening a couple of years ago, and I was having to notify all my clients, right? You were going to have to say who your owners were. And unless you were under certain special exemptions, now it's more for foreign organizations, not the US. Okay, fine. But now there's a whole bunch of new stuff coming down with how property is owned. So I'm over here like, we're not going to be able to create this level of anonymity. Most of the time people are trying to, I mean, that's just my opinion, right?
That's the fencing, right? That's where they have to report. If you're not buying it as an individual,
yeah,
you have
to make reporting. And I didn't even dive into that yet. But yeah, if you're not buying it in certain ways, you have to report who's owning, because again,
it's all cash.
We are trying to go away from this, I'm going to try to hide myself, right? I mean, I don't know. I mean, that's just my opinion. I think it's going to be harder and harder to do that. But also, if I was in the middle of litigation, I would do everything I could to find out. And what we would end up doing is we would be doing discovery, and asking the questions. And then if they weren't answering the questions, we'd be going to court about the questions. And the judge is up there going to say, okay, yeah, you have to say what's going on and who owns it.
What steps do you recommend to take to protect yourself as a business owner?
Hire an attorney.
Right.
Talk to an attorney. I mean, like I do consultations for an hour just as if that's all they need. We just have a conversation of where their business is at and what to do. Insurance policies are really important in the world of property ownership, right? A lot of times people jump to the idea that I should put my rental property in an LLC. Maybe. I don't always jump to that because it just depends on what is the risk of liability. That is my job to analyze. If we have a long-term rental home, you have really good insurance policies on it. Why are we going through the effort in putting it into an LLC?
Because just like you said, you're protecting yourself with the corporate veil. You would think that as a normal person thinking, well, I'm going to create this LLC and then I've got this corporate veil. Now they can't really sue my personal assets, so I'm protected.
But if you got a multi-million-dollar insurance policy on the property, that's what they're going after first. So the likelihood is that something is going to, like if you had a multi-dwelling unit, I have multiple people who can sue me, right? Because there's more work involved. If that client doesn't want to put the work into the LLC, I'd say, no, let's not do that. Just go get a, so it's a client decision. It's not mine to make for them, but we weigh all the factors. The thing that starts happening when people buy multiple properties is that they don't want to have, they should, in order to sequester the liability from each property, they should have it each in an LLC. Mm-hmm. Otherwise, if I had two properties in an LLC, one gets sued, the other's at risk. Okay, so that's not what most people want. But then managing multiple LLCs and then property management on top of that is a lot of work. So like you have to be realistic on your capabilities. I have to assess from the client, like, if you're not good at paperwork, we shouldn't do this because you're going to fail some point and then we're going to have the breach of the corporate veil. And then what's the point of doing all that work, right? So you did it. So that's why sometimes the choice is like, okay, well, I have my house and I got a house from my parents and I want to rent it out. Honestly, most of my clients are going to lean towards, let's just get a good insurance policy and an umbrella policy to help cover no matter what happens. Because that's where they're going to go for. They don't want to come after your person. They're looking to come after your personal assets only for the money. And if you have all the insurance to cover it, well, then we don't need to worry so much.
If your personal assets are also in a trust, can they come after them?
Yep, absolutely. Because I mentioned that before, right? Okay. So I said that you are not protected. The grantors are not protected from creditors. So sometimes people come to me under the mistaken belief that I've put my assets in trust. The creditors can't get me. That's not true.
So would someone suing you be a creditor?
Oh, yeah. I mean, liability. Yeah. I mean, they're not a creditor at that moment. Like if I want to be really technical, but lawsuits are creditors. The trust does not protect you from that unless, and you mentioned irrevocable trust a couple times. It's an irrevocable trust, but that's because the money is not yours. It's not meant for you. You might be managing it or someone else might be managing, but it's not your money. So therefore that is different. But I would never recommend to put your primary residence into an irrevocable trust unless we were trying to do some elder law stuff with you're trying to like qualify for something. That's a different.
So, getting your assets in a trust, you don't own those assets. The trust owns those assets. So I would think
you technically still do.
That's my question to you is like, getting a trust, that's what I would think that whole trust is about and for, like protecting me from creditors and those types of things so that they sue the trust. They don't sue me personally.
No, you're the one you're the trustor, you're the grantor. It's all your stuff. You still can get sued. So that's the difference between you as the grantor. It's all your stuff. It's in the name of the trust. It's still all your stuff. You can still get sued. It can all get taken from you. All that stuff can happen. I mean, there's some things like you guys probably know about people filing homestead exemptions, but you don't have to file those until I don't deal with them that often. I've had some clients ask me, but you don't even have to file them until before the judgment is made. So there's some protections. It's not really estate planning, but there's some things that can be done. But giving money to a beneficiary is treated differently. That beneficiary can be protected from the creditors because if their money is sitting in trust and being held by the trust. But that's not the same for the people that put the stuff in there.
The grantor, the trust.
Yeah.
The trustor.
Yeah, trustor is another term for grantor. Yeah, that can be used interchangeably.
A lot of great information today. We really appreciate you joining us.
Thank you. Thanks for having me.
Yeah. If people want to get a hold of you, what's the best way to do so?
Oh, probably call me my office. Do you want me to give my number?
Sure. Give me your number. Give me your website.
Yeah, it's 916-226-4470, and it's laurencjoneslaw.com. So call my assistant. She's amazing. Everyone loves her. I love her. She will want to talk to you even if you emailed our office, to be perfectly honest, because she wants to help understand what you have going on so she can figure out if we can help you, how we can help you, and when to get you on the schedule. So I just say give us a call, and she'll walk you through the process, and then you get to talk to me later.
I think this has been great. Thank
Yes,
you
thank
so
you.
much.
Yeah.
I mean, estate planning and then also just business questions, business liability questions. And
Yeah.
you do it all. You do basically those are your specific areas of
Expertise.
Yeah.
expertise.
The only thing I don't do is I don't do conservatorship on the estate planning side, and I don't do litigation in business anymore. So like I said, I've done it, but it doesn't fit with my schedule really well. It's more high stress. So I'm not getting into litigation. I will advise people sometimes on, like, we'll have a meeting and we'll say like, okay, does this actually make sense to pursue?
Mhm.
What are the risks for you pursuing it? Is it worth it? Because sometimes you'll get really mad over a very small amount of money, and I'm like, you're going to pay way more in litigation fees than it's worth. So sometimes we walk through that and talk through that, but like actually representing the litigation, we will refer it out. And I don't do employment law. So like sometimes my clients are my business clients. We do formations, we do contracts all the time. We do even like employment contracts and NDAs and things like that. But if you're going to get like employees suing me, or we get to big employment stuff, or like sometimes some really nuanced like issues have been brought across my desk recently about interns and vouchers and things like that. I'm like, you got to go talk to the employment attorneys. They deal with this every day.
Mhm.
The employment laws change all the time. Like they're very well versed in that. So we'll kind of send some of those things out. But
I like the fact that you have litigation experience and most estate planning attorneys don't.
Yeah.
And so that really sets you apart in my opinion, because at the end of the day, you get a lot of those questions. Should I sue them? Should we be suing people, or all these, so you have a background on saying probably not. or
Probably not.
Probably
and I
so.
get those on the estate side too, right? Like I haven't done estate litigation, but I understand how litigation works. And I'll be like, do you want to do this? Is it worth it for you? And then at the end of the game, because when someone dies, emotions are high. Everyone's upset about something. So it's like they immediately jump to like, this isn't fair.
Mhm.
And I'm like, okay, well,
She got
sometimes
the iPad, and I should have had the iPad.
it's like, you want to know what some of the things it is? It's
Sure.
like ashes. Why don't I get these ashes? So-and-so got these ashes. Like, these are things that I'm like, I don't know. We should not go to court over that. We should not. Or sometimes they just want to understand what their rights are, and then we'll have a conversation about that, right? It's a paid consultation. We'll have an entire conversation about what are your rights? What can you pursue? What should you not worry about? They just don't understand the process, and that's fine. I'm here to do that. But yeah, sometimes it's very small little things that I understand have sentimental value, but like you do not want to spend thousands and thousands of dollars in court to fight over who got the ashes. Really, like we really don't want to do that.
Mhm.
So it's things like that, Otherwise, all the other little things tend to like,
Being a voice of reason.
yes. That was
Well-
that psych minor. That's why it comes in handy every day.
Hey, we thank you so much.
Yeah,
and we
thank
could
you.
talk to you all day, to be honest.
I
but
know.
We're gonna wrap it up. One more time, your email address, or your email, and then your website.
Yeah. So the firm is Lawrence C. Jones Law. It's laurencjoneslaw.com. And the number is 916-226-4470.
Great.
Thank you so much.
Thank you, Lauren.
Thanks.
All right.